So in this recording, I'm going to talk about what law actually is. And this is really a question deriving from philosophy. And there's two sort of broad categories of questions that we look at here. Firstly, what makes a law valid? What makes it exist? What makes a law actually look like or be a law or be recognized as such? And the second is what, assuming that there is a valid law, what makes it a good law? Now, in terms of questions that we're going to look at here, we're not really that concerned about the underlying moral truths. We're not really concerned about whether the laws are good or not. We're interested in determining what actually is a law. How can that be determined? And many theories from many schools have tried to make this out over thousands of years of philosophy. So each of these theories I'm just going to talk very briefly about now. So the first area of philosophy we're going to look at is this idea of natural law. Now, fundamentally, the various theories and theorists that group together under the umbrella of natural law all hold really at the heart of that theory that there is some form of universal source. There's some place that we get law from, law in its highest or its purest form, be that through what we might call the laws of nature, some form of essence of humanity, something about our very humanness, or from theology, from God. Now, it's important at this juncture too, I have to stress that natural law and the I guess more technical concept of natural justice are two completely different things. It's very unfortunate actually that they both start with that same first word. Natural law is the umbrella term for a series of theories where there is some essence that the law is derived from. So I guess the first of the natural law theorists that I'll just briefly discuss is Aristotle, a very, very, very famous classical Greek philosopher. And he spoke very briefly about his idea of what the universal law was. But really he was looking at this in terms of ethics. He mentioned almost in passing that the universal laws are all derived from the underlying laws of nature. Now, Aristotle's obviously writing thousands of years ago, and in that situation, when things that we would consider to be philosophy, now we would be tempted to place under the umbrella of science. When he's talking about how the clouds move, or he's talking about how people react to certain sort of stimuli, these may fall under other arms of science. And some areas such as psychology, Aristotle wouldn't, in that particular time, really clearly delineate between the idea of people doing things as a result of their environment and doing things as the result of their, I guess, personal virtue. And so it wasn't very clear in terms of the practical implications of what he really meant by saying that law flows from these laws of nature. So a philosopher who was certainly much more clear about what natural law is was the Catholic scholar St. Thomas Aquinas. Now, Aquinas was writing in the medieval period, and he was a clergyman and a scholar himself, and he drew certainly from reading and translations of Aristotle's work, and also from other Catholic and Stoic philosophers such as St. Augustine. Now, from Aquinas' perspective, there is such a thing as natural law, and it flows from God. And so what he considers to be divine law is immutable and eternal. And really, this idea of a hierarchy is really owed to Aquinas in this sense, in that he identifies that there is this high, perfect form, almost Platonic form, of what the law is, and the laws of people, of humans, they only really they arise when people recognized in the community use their powers of practical reasoning. And again, really, he's writing it in a period when what this really meant was that you would go to the text, you would go to the sacred text, the translations of the Bible, interpret that, and that was where that was how human laws came to be. It starts off with the divine and moves into the I guess the more tangible, the terrestrial, our own world. Now, it's perhaps a little unfair that Aquinas's work is amongst legal philosophers most commonly associated with this phrase, lex aeonusta non est lex, which literally translates to an unjust law is no law at all. And so contemporary scholars are saying that's a little unfair, because Aquinas isn't saying, look, a law that somehow goes against God's will, he's not saying that it's not a law, but and he also says, look, there is sort of scope when you see a law that's been made by a person, because people making laws aren't perfect. They're not the perfect vessels for examining the holy texts and for enshrining that into terrestrial, to our law. He's not saying that you should rage up against the system. In fact, he even accepts that, look, where unjust laws are identified, if there's going to be a lot more harm in raging against that law and ignoring it, don't do that. But importantly, even if you're forced to follow unjust laws, you should know that in your mind. It should not bind the conscience. That's really what Aquinas means by that this lex aeonusta non est lex. Another thing Aquinas was responsible for was the listing out, I guess, some basic things, basic sort of almost like virtues that he considered in his process of reading the text to be basic things that laws that represents, I guess, biblical interpretations of what what the highest level laws should be derived from. And there are some of them: prudence, justice, temperance, faith, hope, and charity. And this idea of having a list of very, very basic things, basic concepts that we can to set our mind to, is something of a theme that reoccurs amongst later natural law philosophers. And so the next of the natural law philosophers that I just want to mention is an Australian philosopher by the name of John Finnis, 20th century. Oh, in fact, he's still alive now. He is an expert on Aquinas, and went back and read and reread the original text, and his own list of things that are, I guess, the basic goods that he constructed was life, knowledge, friendship, play, aesthetic experience, religion, and most importantly, I guess the most important one, the concept of practical reasonableness. This idea that you have to use your faculties of practical reason in order to really live life to the fullest. But fundamentally, he's still stating, look, these are basic goods. They're not derived from anywhere. They don't come from God. They don't come from some sort of logic or induction. They're not inherently wired into the human brain. And to Finnis, really the core of his argument is that it has to be obvious. These things, these goods, these 7 things, have to be self-evident. And it's really a basis to that philosophy, that all forms of law itself flow from these basic premises, or these basic goods. Now, this idea of things being self-evident, this isn't actually a new concept. The US Declaration of Independence, for example, notes all men are created equal and they're endowed by their Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness. And that very famous sentence is actually predated with the phrase, "We hold these truths to be self-evident." In other words, they're not derived from anywhere. We're not taking some other philosophical framework or taking them from psychology. We hold these things as just being good, and we throw our arms up in the air. This is who we are and what we say, and you can either agree or you can disagree with them. And fundamentally, that both the Declaration of Independence and Finis, the entire framework is justified behind that rhetoric. And so the final thing I just want to mention about this concept of natural law is really to do with the common law of the UK and subsequently the common law of Australia. And it really comes from the writings of William Blackstone, who famously in the 1700s wrote a text on the common law of England. And Blackstone and subsequent theorists did actually make the point that natural law itself, in other words, having there being some universal source in which to draw principles from, might actually be useful in determining the content of the common law. For anyone that studied law for long enough will know the phrase time immemorial. That is, the common law of England is always considered to have been in place. It's a convenient legal fiction. Scholars actually went through and found a statute, a very early statute, that actually pointed at a point in time. It's the 6th of July, 1189, is the date at which time immemorial starts. But the idea is that, look, in the English tradition, judges don't make law. Judges merely uncover or reveal what the law already was and has always been in situations where this particular case and the two claimants in this particular set of facts hasn't come up in the past. Now, obviously the world is a lot more complex than it was in Blackstone's time, and there's a lot more sort of statutory codification of things. But it's a useful thing to remember, particularly in the area of law known as equity, things that were brought about where the courts of common law could provide no remedy because there was some form of defect, be it in writing or structure or writ. And the courts of the Chancellor, which were run by priests, used to run as an entire separate system until they were fused in the late 1800s. And so it may be useful to store in the back of your mind this idea of natural law, things deriving from universal principles, when examining and looking at the principles and rules of equity. So now I'll turn to another adjacent and really opposite branch to natural law, which is this area of legal philosophy known as legal positivism. Legal positivism is the idea that law, once enshrined somewhere, is both independent from and not reliant on morality or this universal source that it may or may not have come from. The positivist movement is really started in the early 1800s with two philosophers, Jeremy Bentham and his student John Austin. And largely this was a product of the times. The British Empire by that stage was really rising in power, becoming sort of the first global superpower. And there was this great triumph of science. Science was winning. Science was describing the world. Science was allowing the British to conquer. And so really there is this sort of theme where the early 1800s, the philosophers, the legal philosophy movement, is really trying to reject the works of people like Blackstone as being archaic, as being sort of medieval, and the common law itself as being something which is, if possible, to be done away with. And so we'll start with Austin. Austin was actually the student, but it may be more helpful to look at his theory first, because his theory of legal positivism is that the law and laws are an extension of the sovereign. They're commands, they're orders of the all-powerful sovereign, backed by sanctions, backed by some form of penalty if a person was not to comply. And so in Austin's theory, that the threat of these sanctions sort of coerces people into doing and not doing certain things, and that coercion over a long time really just forms patterns. It forms habits. Those threats on sanctions, threats of sanctions by the sovereign, forms habits of obedience. Now, you may probably have already just thought, well, that's a bit problematic in terms of more recent areas, and it certainly is. It doesn't really describe the 21st century as well as it may have in the early 1800s. It certainly doesn't describe this massive quantity of regulatory laws and things that aren't necessarily coercive in how they operate. They're merely to make things tidy. It also doesn't easily describe the areas that we would look at in terms of constitutional law, things where we're actually looking at how the sovereign's powers sit, and how these things can be challenged, and certainly the administrative law aspect of it. It doesn't at all describe international law, where you've got competing sovereigns, and it doesn't very well describe anything to do with customs and habits that people have formed that aren't related to law. And the whole point of the exercise here is to try and determine what a law is. That's difficult to do if people do certain things without there ever being a law, and that's really some of the heavy criticism that comes to Austin's theory, although it is still useful when trying to analyse, particularly for areas like the criminal law, where it can fit quite elegantly. So I'll turn now to Austin's teacher, who's Jeremy Bentham. He's the father of the area of philosophy known as utilitarianism, and certainly his legal philosophy was very much in alignment with that idea of doing things in almost a methodical, a scientific way. And so Bentham's philosophy can be thought of more as a project in relation to law. From Bentham's perspective, the common law that was espoused as being this wonderful thing by Blackstone in the previous century, he thought was a terrible thing. Common law is self-serving, it's corrupt, and most importantly, it's retrospective. And you can really see his argument here. Look, essentially, two people go to court to determine what their rights are, but by the time they get to court, the time between the day of the hearing, or in fact even longer, the day of the actual delivery of the judgment, and when the particular event happened, can be a very, very long time, sometimes years. For those that have ever had to deal with the profession, you can wait many years for cases to finally get resolved. The courts operate at their own time and at their own pace. And so the problem with this is that, look, we're asking the court to resolve something by determining what the rights of the parties are, possibly years after the event happening. So really what they're doing is retrospectively creating the law. And that's extremely problematic, or at least Bentham thought that is very problematic. Law should always be prospective. And from his perspective, this whole idea of determining what laws are valid is through this process of codification, so that and again it's a product of the times, as people were getting more literate, in Bentham's ideal world, a citizen can just go to the code, open the book, and see what the law is. And this sounds like in our age of mobile devices that can retrieve the sum of human knowledge within a few seconds, this idea of codifying the law may seem a bit quaint, but in Bentham's time this was quite revolutionary, and it's really, in terms of Bentham's project, this codification process is really a response to to Blackstone's own project of extolling the virtues of the flexible common law. Bentham says no, flexibility is not really the issue. The issue is retrospectivity and uncertainty. Put it in a book, and we can all see what it is. And certainly throughout the 1800s, it took a little bit of a while, but towards the end of the 19th century, a lot of the criminal codes were published around that time. And certainly in the state of Queensland, the Griffith Code is very much an embodiment of Bentham's philosophy. Hey, let's get all of the existing common law offences and put them into one piece of legislation. So a citizen can merely open the book. Of course, there are some great problems with that, largely to do with language. It's something that wasn't really recognised until the 20th century, that language is actually quite fluid. You can't put all of the words into a code, otherwise you're really having to put the entire dictionary in there. And that's a problem, because dictionary makers don't make law, Parliament does. And so Bentham's work in terms of codifying things was very, very far-reaching. Certainly an example of a philosopher whose theories had a very long-standing, long-term impact on the law itself. So I'll turn now to Hans Kelsen. Kelsen was European-Austrian, I believe. His theory of legal positivism is very much grounded in science. He's really trying to use the tools of science to try and determine the validity of things that may or may not be laws. And so the first thing that he does is to separate statements into what we call normative statements. Normative statements have words like ought, this ought to be, and separate those from descriptive statements, things that say what something is or what it will be. And this flows from an Enlightenment philosopher, Scotsman called David Hume, who really separated these two ideas out, and the idea that you can't derive one from the other. You can't make an ought statement from an is. Now, Kelsen's legal norms, he's really talking about these ought statements. So thieves ought to be punished. That's really the basis of what his work is. The series of normative claims or statements. He's not concerned about whether thieves are punished or whether thieves will be punished. That's not really, from his perspective, that's not really law. What he says, and it's really the framework that he's operating with, is that legal norms will always contain some form of sanction, or at least are connected in a series to a legal norm that has some form of sanction. And the most important thing to take away from Kelsen's work is that all legal norms derive from one great norm, one great normative statement or institution by which all other, legal norms derive from. So, for example, the Australian Constitution. As a normative statement, we can say, I ought to obey the Constitution. That really doesn't mean very much. So we can go a bit further down in the hierarchy and say, well, what that really means is that, I ought to obey laws passed validly through the federal parliament, stamped by the upper house, stamped by the Governor General, and passed into law. And again, that's a very broad statement. So what if we narrow that again to be more specific? I ought to obey the Income Tax Assessment Act, 1997 Commonwealth, or the Tax Administration Act. I ought to obey the various tax statutes that the federal government issues. And so from that, we can derive a statement of what I ought to do. I ought to give the ATO some money. Now this can be contrasted with other entities or peoples essentially doing the same thing. Somebody pointing a gun to my head and saying, give me all your money. I'm giving all my money to the ATO or the person with the gun pointed to my head. However, I only identify one of those as being flowing from the law, because on the one hand, the person with the gun doesn't have any chain or series that leads back to the highest level norm. In this case, the example I use is obeying the Constitution, whereas me paying the ATO does. And while it's a little bit complex to try and get your head around, Kelson's theory, which is very solidly and methodically argued, does certainly have some interest, and I think another takeaway from that is in terms of the style. It's a very, very methodical style that he's using, grounded in science, to try and determine an answer to the question that all of the other theorists are trying to argue, that idea of what is law and what makes a law valid. And so for him, it's whether or not there's that chain that leads back to the grund norm. So I'll move on to another well-known legal positivist in the 20th century. It's the theorist HLA Hart. Now, Hart's theory of legal positivism, I guess a more sophisticated one than Austin and Bentham in the 1800s. And really, he's wholeheartedly rejecting this idea that law, and valid law, requires some form of sanction. So from Hart's perspective, law is a social phenomena. It's something that people do. It's something that I guess that if we can't deny our own existence, and we certainly can't deny the existence of others, we look at the relations between those people and the identification of norms and rules, and in particular the types of rules that may or may not be laws. And that's really what how Hart goes about grounding his theory. And his theory is based on this sort of a two-tier system of rules. The primary rules that are, I guess, are required in order to stop us from doing terrible things to each other, to suppress violence, to facilitate coexistence. And that includes things like the rules for contracts and the rules for governing, say, family law and such like, company law. They're the primary rules. The secondary rules fall under three types. There are rules to do with changing the primary rules. In other words, how do we go about actually changing the laws of the land in terms of Parliament and the courts changing rules. The adjudication, how do we, when there is a clash between two people disagreeing on the laws, how is that actually resolved? And most importantly, this secondary rule of being able to identify what the primary rules are. So this third one, and Hart refers to it as the rule of recognition. It's a sociological process. It's really both citizens and officials looking to social rules and norms that people do or don't do, to actually determine whether they are laws or not. So, to step this back a bit, there are certain things that we will do in our day-to-day life. wear certain types of clothes, for example. Now, whether you wear tidy clothes when you go to, for example, a ball, or you wear casual clothes when you go to a ball, that's a rule, a social rule or a convention. But we don't identify that as being a law. Now, the flip side of that, there may be things that that some people might consider to be a bit stronger in terms of codes of conduct. Swearing around small children, for example, and, using foul language. Interestingly, in North Queensland, where I reside, it's far more socially acceptable to use very colourful metaphors in and around small children. Other places where, in other cultures, other cities within the same culture, essentially, so the large metropolitan centres in Australia and New Zealand, the social norms are somewhat different. Now, the question is that a law or not? And it's a difficult thing to answer, because often the actual codified rules and the discretion that are given to, say, police officers and magistrates in this case, have a very wide amount of discretion. And so it's difficult for us as citizens from time to time to actually determine whether or not a person doing something is actually against the law or just against some form of social convention. And so that's really what Hart is interested in. He, from his theory, he looks at what people actually do. The law as a sociological process. What do people actually recognise as being laws? People, by the way, this includes citizens and also officials. There are a whole heap of people that don't think certain laws either ought to be laws or are laws, and there are officials who like to burst that bubble. Certainly in terms of things like the traffic sphere and walking, jaywalking, and so on. Now, Hart's theory is it's very enduring, it's very well known, and it is quite complex. But it's fundamentally grounded, though, in this idea of a 20th century phenomenon of sociological analysis. So the very last theory or theorist that I want to mention is a chap recently deceased by the name of Ronald Dworkin. Now, Dworkin's theory doesn't sit very well within the bounds of positivism or natural law. Dworkin's theory essentially is a response to Hart and rejects this idea of law as a social phenomena. From Dworkin's perspective, law is really something that embodies a series of principles, and most importantly in those principles is to do with the upholding of rights. Dworkin's theory, which again tends towards, I guess, the more sort of USA style of jurisprudence, where judges can draw on their constitution, have a lot of power and scope to draw upon the US Constitution in order to resolve cases. And from Dworkin's perspective, that's what judges do. Judges pick and choose principles in order to, and this is the phrase he uses, in order to maintain the integrity or the seamless web that is the law. That judges are intentionally trying to maintain the integrity of the law and uphold rights. And so that they do this pick and choose, where they are confronted with a series of principles, legal sources. They pick or try to pick the best principles in order to uphold rights in any given situation. Now, you're probably thinking to yourself, well, that's a little bit problematic, because, well, whose rights? Particularly when you've got a situation where you've got two parties competing, which is really how every single court case arises in an adversarial system. the two parties come together, we can't determine who's right and who's wrong. We need the judge to do that. And so Dworkin uses this his thought experiment where he constructs this idea of Justice Hercules J, who is able to pick from all of the legal principles available and determine the correct outcome. Now, again, he's seeking to uphold rights, and sometimes somebody's going to gain some rights and somebody's going to lose some rights. However, to Dworkin, that's not a problem, provided the integrity of the law is maintained. That's really what his theory is grounded in. Dworkin's work is one where it's very much grounded in a system of rights, and not really that much grounded in anything to do with practice in terms of what people do. It's not really to do with any form of sanction or any sort of sociological phenomena. And so Dworkin also responds to this idea that he's been criticised, that, isn't this idea of rights a natural law phenomenon? And he argues strongly against that, saying that it's not actually the deriving of rights as a universal good. It's really to do with the integrity of the system. He does sort of say that law is fundamentally about rights, and that at the end of the day, this rights need to trump anything external to that. So rights themselves are the core part of Dworkin's theory.